Hello, I am Martha Minow, and I am grateful to Deans Manning and Sells and a great team of others for bringing us together during this challenging and uncertain time. No matter what, we are here, and we are here to learn about law, about institutions, about making the world better, and that includes supporting one another during challenging times. We're here to hear from this outstanding group of experts following the US election and in the midst of continuing uncertainty. We hope to learn what has happened, what is happening now, and what must happen next. What does this all mean for law, democracy, the United States, and the world? Please post questions in the question and answer function on the Zoom screen. While the law school is and must remain nonpartisan, we as individuals can and will express our views, our concerns, and our hopes. For myself, I just want to note that no matter what unfolds with this presidential election, with the Senate and other election returns, let's face facts. Much of the electoral process in the United States is severely faulty. People standing in line for 7 and more hours to vote. Mail-in votes that are lost and not counted. Thousands of lawyers working currently on litigation, challenging the results and defending the results. Voter suppression issues, not to mention the US Postal Service refusal to comply with a court order to locate and deliver undelivered mail-in ballots. Polling is broken. The news ecosystem is hijacked by false and misrepresentative news, and it reflects and fuels divisions over everything, including basic facts. From my own perspective, the fact that some 66 million people voted for a president who foments disrespect for this electoral process, for the courts, for the media, for the norms of democracy, for the peaceful transition of power, for decency, who encourages racism, hatred of immigrants, hatred of people with different political views. This is a crisis, no matter who becomes the president going forward. Quite apart from party differences about healthcare, abortion, immigration, racism, environmental protection, COVID-19 protection, science, reason, this means that we are fundamentally divided about what it means to be the United States and how do we run this nation. We're divided over the roles of courts, legislatures, the states, the federal government, all of whom have a role in our future and will decide what our future will be. But no one's more important than the people in this country. And I am very much looking forward to how our panelists will help us make sense of this challenging time. It's a time when all of us need to play a role because no one is going to come and save the day. We will have to save ourselves. I am so delighted to be able to turn here to some true experts who bring a wide range of deep knowledge. They will share their views and immediate reflections. I will then offer some questions and invite them to comment on one another's remarks and then turn to the audience and for your thoughts. Ruth Greenwood leads the Voting Rights Litigation and Advocacy Clinic here at Harvard Law School and draws on her extensive experiences in voter protection, gerrymandering, and indeed the entire range of legal issues affecting voting. Larry Lessig has worked on the law of democracy as a scholar, as a lawyer, activist, and candidate, while also pursuing landmark work on anti-corruption, internet law, and constitutional law. The Royal Furman Professor here, he is the author recently of They Don't Represent Us, Reclaiming Our Democracy. Kenneth Mack teaches and writes about legal and constitutional history with particular emphasis on politics, economic life, and race relations in America. Regularly commenting on political affairs in the national media, Kenneth is the Lawrence D. Beale Professor of Law at Harvard Law School and an affiliate professor of history at Harvard University. And Nick Stephanopoulos, a leading scholar and participant in the work of election law, constitutional law, and the law of democracy, is professor at Harvard Law School and a sought-after expert by national media and litigators in the field. Ruth.
Yes, hello. Hi, everybody. It's a pleasure to be here with everybody. And I think I've spoken with some of you before, so you hopefully know that I am forever the optimist. And so I want to go over my initial reactions to Election Day, that things went pretty well, right? We didn't have, and I'm going to put aside what's happening now, we didn't have civil unrest. Though we had long lines, we had people stay in their lines and we had them able to vote. We didn't have, it doesn't seem as though we had widespread transmission of COVID, which, you know, and there was a lot of PPE and everything. And basically we had a huge turnout, right? Bigger turnout than we've had before, which to some extent is because we have more people now, but even as a percentage, we saw turnout increase. So enthusiasm was high. The election administrators did their job under very trying circumstances. So overall, I think they are very good signs for our democracy. Now, the other thing we were worried about, or one of the other things I was worried about was this issue of the count taking a long time. And maybe it's because I listen to NPR a lot, but a lot of the news has seemed to be echoing what the election lawyers are saying, which is we've just got to keep waiting. We have to be patient. We have to wait until we get all of the votes in. Now, I know that that is not the position of everybody. There are certain candidates who are not saying that. But it seems as though the stop the count type rhetoric is not getting picked up across the board. And so I think that it is good that people seem to be understanding that we need to wait. I mean, I guess there's the helpful fact that if you stopped the count right now, you know, Trump is asking for you to stop the count, that he would not be president. So that's maybe a helpful fact. So overall, I think in terms of election administration and in terms of managing the mood, we did a lot of work this year to try to get that to a good place. You know, Twitter is notifying everybody when somebody tries to claim victory before it's actually been called. So all of that work has gone well. That said, there are 10 plus lawsuits in Pennsylvania that I'm tracking, a whole bunch in Georgia, Arizona, I mean, everywhere else. So we have the somewhat expected flurry of lawsuits. Many of them are not particularly serious, although they all have the potential to kind of become more serious if they end up actually being facts to support them. For example, what Professor Minow was talking about with the United States Postal Service on Election Day. If you want to see what a cool judge can do, Judge Sullivan basically said, I'm going to order you to go and sweep through post offices, find ballots and deliver them. And then in response, USPS did not follow that order. And then yesterday at a hearing, Judge Sullivan said, I'm going to have the Postmaster General come to my court and tell me why he did not comply with my order. And when the DOJ lawyer said, okay, well, I'll just work out his availability, the judge said, no, I'll tell him when I want him to come. So, I guess sometimes I don't like judges being quite so activist, but in this case, it was great. And also, if you look at the numbers coming out of that, it didn't seem as though we're talking about hundreds of thousands of ballots that were getting left behind. The other thing I think that is good for democracy in this case is that if you're talking about an election that is being won by even tens of thousands of votes, that means that some of these questions about, did the ballot arrive before 7 p.m. on election day or not in some places are not going to make the difference. When the election is a couple of hundred votes different, as it was in Bush v. Gore in 2000, then we can expect there to be a problem with exactly cutting out which ballots do count and which ballots don't count. So my hope is that in the next few days, we end up with in the tens of thousands range in all of the states, no matter who wins. And so there may be recounts, but as even Scott Walker said about Wisconsin, right, recounts can change. I think in 2016, they changed 131 votes. Historically, they've changed about 300 at the most. That is not going to change 20,000 plus votes. And so hopefully the legitimacy of the results, at least at the presidential election, will be something that all of the media can get behind. Obviously, it remains to be seen. I think that some of these lawsuits I'm hoping will end up being mooted or withdrawn, because when you file lawsuits with very flimsy theories and very few facts, it has the potential to make really bad law. But so far, at least all the ones I've seen, I think in the last 15 minutes that I've been tracking, one in Georgia and one in Pennsylvania both got dismissed for lack of evidence. So I hope that that continues. The potentially worrying thing, and this is where I will hand over to Larry, is I saw on election day that I think it was the Senate Republicans in Pennsylvania wrote a whole thing about how they thought they should fire the Secretary of State for not doing her job, which I seemed to be written in a way that was a prelude to them saying, and therefore we must, as the legislature, take over and appoint, the Electoral College voters. And if that were to happen, I think that would be problematic. I don't know whether we'll get through the Electoral College process okay, but I do think at least in terms of election day, we got there. And I guess the other thing, I felt very much after election day, like coming out of a settlement conference, like, yeah, I have not been a fan of a president that tries to suppress the vote. But what I really do want as well is lots of independent commissions. Meanwhile, the one in Missouri was struck down, independent commissions for redistricting. What I want is divided control in states, again, for redistricting, and I didn't get that. Innovative new electoral systems like ranked choice voting, and here in Massachusetts, it didn't get approved. So I didn't get everything I wanted, but it wasn't a disaster for anyone, I don't think. So that's where I'm feeling right now. I'm going to hand over to Larry to give us a preview of the Electoral College.
Yeah, thanks. This could be the calm before the storm. Or in the next 12 hours, we'll see that this whole fight is going to fizzle. But let me play out the calm before the storm scenario. The terrifying thing about this election cycle is, for the first time in forever, we have a candidate explicitly talking about trying to trigger either a statutory or a constitutional authority of state legislatures to appoint alternative slates of electors. Now, we kind of expected that the predicate for that would have been set up in a more aggressive way than it has. And what's astonishing is just the ineptitude of the actual lawyering around this potentiality. And it doesn't seem they're actually prepared. I mean, the report yesterday in the New York Times was that Kushner was recruiting lawyers yesterday for the purpose of figuring out how to litigate the post-election fights. So it might be that, again, this all fizzles out. But if it doesn't fizzle out, here's the structure of the problem as the law sets it up. If a state asserts, either under 3 U.S.C. 2, which is a weird statute from 1845, or under a burgeoning constitutional theory first suggested by Chief Justice Rehnquist in Bush versus Gore, recently reaffirmed by Justice Kavanaugh, and likely supported by Justice Barrett, that there's a kind of superpower in legislatures to appoint slate of electors whenever they want. As Bush versus Gore said, the power once vested in the people could be reclaimed, quote, at any time. And if that power is not deemed to be constrained by other constitutional provisions like the Due Process Clause, equal protection, or even the First Amendment, then in theory, you could see state legislatures appointing alternative slates predicated on claims of fraud or whatever else they want to predicate it on. But the interesting twist is that the statute that governs the counting of electoral votes in the context of competing slates of electors has this weird tie-breaking formula for competing slates of electors. So if you have competing slates of electors and each have not succeeded in achieving safe harbor status, then if Congress agrees on the slate that should count, that slate counts. But if Congress is divided and the slates are partisan in the way we expect them to be, then Congress is not going to resolve it. And so the only resolution is this tie-breaking procedure that says the slate signed by the governor or certified by the governor is the slate that gets counted. Okay, so what that means is that Republicans in Pennsylvania can threaten all they want. It's a Democratic governor. And so if you look across the country at the states that Biden has won or may win, the only two states where this game could play is either Arizona or Georgia. Arizona has a Republican legislature and a Republican governor. Georgia has a Republican legislature and a Republican governor. And so conceivably, you could see in either of those contexts this constitutional power being asserted and then exercised for the purpose of multiplying slates, which then the Republican governor signs, and according to the Electoral Count Act, that slate must then be counted despite its inconsistency with presumptively what happened in the vote. And then there's a huge question, first, whether the Supreme Court would even step in, because if ever there's a question that's committed to a separate branch, it's the counting of electoral votes committed to Congress. And then if it does step in, whether the court would uphold the procedure of the Electoral Count Act, which some have charged itself as unconstitutional. Now there's let me just add one little twist to this. So there's one state, and only one state, that has explicitly passed a statute that invokes the power that Congress has given states if an election has, quote, failed to select an alternative slate of electors. That state is North Carolina. North Carolina has a statute that explicitly says, under the power given to us by 3 U.S.C. 2, we set up the following procedure. And the procedure says, if the election is not resolved 6 days before the electoral votes are supposed to be counted, so that's within the scope of the safe harbor provision of the Electoral Count Act, then the legislature gets to appoint an alternative slate of electors. And if it's not selected a day before the electors are supposed to vote, then it's the governor who gets to select a slate of electors. And in either case, the slate that gets selected gets to cast its votes according to how it thinks North Carolina wants to vote. But that judgment is not subject to judicial review. Okay, but here's the trick to it. The legislature is not in session. And the only way the legislature can come into session is if 3/5 of the legislature vote to go into session. And the Republicans don't have a 3/5 majority in the North Carolina legislature, which means the Republicans will not be able to call the legislature into session for the purpose of selecting an alternative slate if the contest is not resolved, which means it falls to the governor, who is a Democrat. So you can see that if there's a game being played in Arizona or in Georgia, the Democrats could play a counter game in North Carolina. And obviously that itself is incredibly destabilizing. One last point to make sure people begin talking about it more. Bush v. Gore was an incredibly poor opinion in reflecting on the actual history of the electoral counts in contested elections. It made it sound like there was some constitutional or statutory reason why all of this had to be resolved prior to the safe harbor date, which is 6 days before the Electoral College votes. But there was an extraordinarily important bit of precedent that the Supreme Court just ignored, which was Hawaii in 1960. In 1960, Hawaii originally went for Nixon. At the end of November, the governor certified a slate of electors for the Republicans. There was then a recount, and the result flipped. It went for Kennedy by about 114 votes. And the governor at the end of December, and that was decided at the end of December, the governor in the beginning of January certified another slate. And then they got that slate, they put that slate on an airplane and they flew it to Congress, and it arrived on the morning that Congress was deciding. Now the trick is that both of those slates had gathered on the day that the Electoral College is to vote, and they both had voted. They both had cast votes. So that the governor, when he affirmed that in fact it was the Kennedy slate that was the slate for Hawaii, could point to the votes of that slate on the day that Congress had certified. And when Nixon, who was the vice president, president of the Senate, came to Hawaii, he acknowledged both slates, but he said not to raise a precedent, he would count the Kennedy slates because that was the slate certified by the governor as the slate representing the state. Now, that history, I think, should give special counsel to states like Pennsylvania, who should not listen to people who say you need to get this done by 6 days before the electoral colleges to vote, but instead to take their time to make sure they are actually counting the votes honestly and fairly. And the procedure should certainly allow them to do that so long as the electors from both slates vote on December 14th and make sure they preserve their status as electors who've cast their votes in a timely fashion. So that too is uncertain. All of this is uncertain. My hope is that in 12 hours, this uncertainty goes away and we just have a settlement on what seems to be the increasing trend in the results. Okay, I'm sorry. My job now is to ask Ken Mack, we're going in alphabetical order, to then add his perspective.
Okay, thanks Larry and Ruth for those great introductions. I'm a historian, so I'm almost the last person to tell us kind of how we should assess what's happened in the last few days or what's going to happen in the next few days or for a few weeks. But there's a couple things we really do know. We tend to think of certain elections as terrifically important from the perspective of history and that they changed a particular political coalition. They enacted a particular set of policies, elections like 1896, 1932, 1980. And as recently as 2008, people were predicting what was then called a, quote, emerging Democratic majority, signified by Barack Obama's election that was going to, go forward with all of this new policy. And we kind of know how that worked out. Worked out kind of unevenly. We did get new policy, but it was uneven. So I'm going to talk about a few things that I think we do know, and then maybe return to this question that's really going to animate this panel, which is sort of how to think about what's going to happen over the next few days or few weeks or few months. Okay, a few things we do know. Well, we do know it's very likely that Biden-Harris will retain a majority, will retain a winning coalition of votes that are actually counted. If that's true, then it's likely that a woman of color will be elected vice president of the United States for the first time. We know that Black candidates appeared to run competitively in statewide elections in multiple Southern states, and I say appeared. Those elections don't seem to have been as close as they were predicted to be, and we're going to have a lot of discussion going forward as to whether these particular contests were significant or not. We also know that there are a lot of things that are not necessarily tied to the election outcome have been in motion and will continue to be in motion. For instance, what's been going on in 2020, which we might call a national movement to counter what is called structural racism, which will continue. And in fact, many Black Lives Matter activists have explicitly said, counseled caution, put it that way, in thinking about what's happened in November as any turning point for their movement. We know that there was a bipartisan movement around certain pragmatic reforms, such as decarceration of nonviolent offenders. And maybe that might continue. Okay, so there are all these things that seem less connected to what's just happened and what's going to happen over the next few days, few weeks, or few months. Okay, now to turn to the things that are, really at issue at this moment. For a generation after the civil rights movement, there appeared to be a national consensus on expanding voting rights, particularly for the most vulnerable, those with least access to governmental power. That consensus has been in tatters. There's been an attack on voting rights, particularly minority voting rights, that's been at work for years. And we should expect that attack to continue apace. There's been a way in which the discourse of fraud around voting has in so many instances centered on areas with a lot of Black voters. That's historically where the discourse of fraud in voting, or at least one of the historic loci of the discourse of fraud in voting, going all the way back to Reconstruction. We might note that in this particular election, places like Philadelphia, Atlanta, and Fulton County seem to be the locus of this. So not only, there are other places. And there's been this discourse about fraud and fraudulent voting that seems to run through, disproportionately through, Black voters. And from my perspective, that's not an accident. Turning more specifically to what's going to happen over the next few weeks and a few months, there's this question, and you know, I liked Ruth's optimism, and I want to be optimistic, but we also might say that the underlying norms that govern voting are actually under assault. Donald Trump's statement on election night that he won the election and we should stop voting. There's going to be litigation over the next few months. You know, there's a big, you know, Larry suggested, well, maybe it will peter out, maybe it will peter out, maybe it won't. But there are all these processes, but more important, there are all these norms that govern when an election is resolved. The processes may, in fact, not resolve it. It's the norms that actually do resolve it. And the norms do appear to be in danger. I think we will know over the next few days or few weeks or a few months whether the norms that allow us to actually resolve elections are going to be continued or are going to be altered or perhaps be in tatters. So there's a lot that's going to be at stake in the next few weeks or few months or few days. Finally, I should suggest, you know, we've got a lot of people on the Zoom call today. I assume a lot of you are law students or otherwise members of the law school community. There's a question of what do we do? We teach about institutions. It is clear that institutions are changing in ways that are not going to go back to the status quo. The press is changing, political institutions are changing, new challenges to voting, both the processes of voting and the norms that underlie voting. There's going to be a lot of work for us to figure out what to do. I think whatever happens in the next few days, few weeks, or few months, there is no going back to the world that existed before. We're in a period of rapid institutional and norm changes in institutions and norms, and it's going to be up to us to figure out how to respond. Okay, with that, I am going to hand it off to my co-panelist, Nick Stephanopoulos, who will take us forward, and then we'll continue the conversation. Thanks.
Great, thank you, Ken. So I thought I would say a few words first about the recent Trump campaign litigation that's now unfolding in several states across the country. And then I would try to take a step back and think about what this election is likely to mean for American democracy if the election comes out the way it's looking right now, both for the presidency, but also for the Senate and the House. So, you know, starting narrow with the ongoing Trump campaign litigation, it's all fairly small bore at the moment. So the barrage of lawsuits filed yesterday and today have involved things as mundane as how far away observers have to be from the vote counting process, what's going to happen with a particular county in Pennsylvania that gave a few voters the chance to fix defects in their mail-in ballots. In Michigan, is there any concern when apparently a single Republican observer from a single rural county didn't get the access that the Trump campaign thought he should get to the vote counting process? In Georgia, there are a handful of late arriving ballots that were supposedly commingled with other ballots, but there appears to be nothing much to the story. So, you know, the important points about these cases, in my view, are a few. One is that none of these cases seem to affect substantial numbers of ballots. And so at the moment, there seems to be no plausible scenario where these lawsuits could swing enough votes, no matter how they come out, to decide the outcome of any state's election. Election lawyers often talk about the concept of the margin of litigation. How close does a state's outcome have to be so that lawsuits could plausibly threaten to change the outcome? None of the lawsuits filed so far seem to be within that margin where a lawsuit could make a real difference. The other key point about these claims is that so far, at least, they're almost all, with one exception, claims filed in state court, solely alleging violations of state law. Again, with one minor exception, none of these cases raise any federal issues, any constitutional issues. And so there's no obvious path for any of these cases so far to get to the Supreme Court or even the federal judiciary. They appear to be so far sort of garden variety disputes about the implementation of state election laws. And I guess a final point about these lawsuits is that the remedy the Trump campaign is seeking, at least rhetorically, is totally unrelated to the substance of these alleged violations. The Trump campaign has been saying that it wants the vote count to stop in places like Pennsylvania or Nevada or Georgia. But even if there are some issues with observers' access to the voting process, or about how certain ballots were or weren't cured, about whether certain ballots were mingled when they shouldn't have been mingled, by no means would the right remedy be stopping the count. The right remedy would be a very targeted injunction to fix whatever that small bore violation is. So on the whole, I'm kind of puzzled and a little bit comforted by the litigation strategy we've seen so far. It's such small potatoes litigation that it doesn't appear to be any significant threat to the vote counting process or to the results in these states. Okay, so if that's right, if the litigation is no threat, and if, as it appears based on the tallies so far, Biden ends up being elected president, what is this going to mean for our democracy over the next few years? Here it's crucial that it also appears that the Senate is going to be in Republican hands. There's likely not going to be unified Democratic government in Washington in 2021. And if that's right, that immediately takes off the table a couple of potential sweeping reforms. One of those reforms would have been dramatic federal electoral reform along the lines of what the House passed in early 2019. This would have been reform of the voting process, of redistricting, of ethics and anti-corruption law, of money in politics. But it appears with Mitch McConnell running the Senate that none of this omnibus reform legislation will become law. There had also been a lot of talk in recent weeks about Supreme Court reform, changing the composition of the court, adding members, adding term limits for members of the court. That also appears to be entirely off the table. And so it now seems likely that we're not going to get any great change in the election jurisprudence of the court, or if there is any change, it's going to be further change in a conservative direction. So any hope one might have had of a differently composed Supreme Court fighting gerrymandering, upholding restrictions on money in politics, striking down barriers to voting, really trying to promote instead of hinder American democracy, I don't think that's going to happen. And if anything, the Supreme Court is likely to become more of an obstacle for those who believe in democratic values than it has been in recent years. So last thing then, if federal legislative reform is now implausible in the medium term, what could a future Biden administration do to promote democracy? There actually are a number of things. So the Department of Justice is the federal agency that enforces some pretty sweeping existing laws about elections, like the Voting Rights Act, the National Voter Registration Act, the Help America Vote Act. So a DOJ run by officials who wanted to make American democracy work better could do far more than the DOJ has done in recent years, whether under Democratic or Republican control, I might say. The DOJ could fight voting barriers around the country. The DOJ could challenge district maps that dilute the influence of minority voters. The DOJ could fight purges of the voter rolls. The DOJ could deploy observers and monitors in elections around the country to prevent voter intimidation. There are so many avenues that a sufficiently motivated DOJ could pursue without needing any fresh legislative authorization. So I would really hope that a Biden administration facing divided government would make the most of that lever to push for democratic change. One last thing I'll note, which is even more aggressive and more radical than the DOJ doing new things, is that under Article 1, Section 5 of the Constitution, the House is the judge of the elections and the qualifications of its own members. And so using that power, the House could do a lot of things to make congressional elections better. A majority of the House could say, we're not going to seat members elected from gerrymandered districts. We're not going to seat members elected via elections that are marked by voter suppression or voter intimidation. This would be kind of a nuclear bomb. If a single chamber of Congress decided to implement these kinds of proposals, but it's well within the power of the House to do so. It's a non-justiciable power that the House holds. And so if the House were sufficiently motivated, it alone, without the concurrence of the Senate or the president, could take some really dramatic steps to improve congressional elections specifically. So I'll stop there, and I look forward to hearing comments and questions from the other participants in this call.
Thank you all. Those were just splendid remarks and very illuminating. I want to start with the question, to what extent is this an unprecedented situation? An election too close to call for days, maybe weeks? What lessons can we learn from Bush v. Gore or other historical episodes when it has been this close? We have a claim of a need of a recount. We've seen that before. What can we learn from the past, and how different is this time? Who would like to comment on that?
I'm happy to start. Without stepping on Ken's historian's toes here, I think the real historical precedent is 1876, which was the last time you had a real contest with multiple slates of electors being submitted. Although even then, no legislature purported to have the power to select a slate against the vote of the people. It actually was just a process of having competing boards of elections that were just arguing about what was the right standard to be applied. But that was the closest. And of course, the Electoral Count Act was enacted a dozen years after that for the purpose of resolving this struggle when you had multiple slates. And since then, there's been only 2 times we've had multiple slates. The first time was immediately after the Electoral Count Act, when a state, Oregon, submitted a slate as a joke to see whether the system worked, and it worked. They didn't count it. and then 1960, as I've described. I've not yet seen that anybody outside of the Trump campaign has really embraced the idea that they could play, this is a real nuclear move, that they can play this move. And I actually think that their constitutional power to do so has been undercut by the Cefalo decision, which, if Cefalo says electors aren't free because democracy now rules, why are legislatures free in the face of democracy ruling? So I don't think it's actually clear or possible for them to act, but I think that this would really be unprecedented, something we've not seen in more than 140 years.
Thank you. Does anyone else want to comment?
Yeah, let me chime in, Martha. So we see the Biden campaign, at least, seeming to have learned a couple of lessons from the Bush v. Gore experience. So one thing that weakened Gore's case back in 2000 was that he initially conceded the election in Florida to Bush and then rescinded his concession. And so there was nothing like that by the Biden campaign. No concessions, also no claims to victory until all the votes are counted. Another perceived error in the Gore tactics back in 2000 was that Gore got a little bit cute. Instead of having a very clear message, just count every vote and let the people speak. Gore asked for recounts in some counties, but not others. Gore tried to stop late arriving military ballots from being counted because they were thought to be pro-Republican. And so all of that really confused Gore's message and looked like he was just trying to game the system for partisan advantage. So the Biden campaign's line has been much simpler. Count every vote, we'll abide by the decision, but we have to wait until every single vote is counted. So I think so far they're really showing that they've learned the lessons from 2000.
Yeah, I would agree with what Larry and Nick have said. I might, just depend a little bit about the 1876 analogy. It's true that the basic claim to be able to appoint a slate of electors is that you're reflecting the will of the people. And there were competing slates in 1876, and each competing slate supposedly reflected the will of the people because it was rampant voter intimidation and actually murder in many of the southern states to intimidate particularly Black voters. But there are competing claims right now about who won these states, and there's a lot of self-deception that's being articulated right now about those kinds of claims. There's been a fostering of skepticism about the results. So, I hope that, the norm that Larry's articulated would prove constraining. But I also don't underestimate the power of state legislatures or politicians to engage in self-deception about who actually won.
I would just add that I think that given that we are so polarized and partisan, it is useful to have Republicans come out and say that they agree with the result, whatever it gets announced to be. So, hearing Ben Ginsburg, lawyer in Bush v. Gore, also lawyer for Mitt Romney, coming out and saying, look, I don't think there's a lot to these lawsuits. I don't think this is going to the Supreme Court. I think we're fine for now. I think is really helpful. The thing I'm a little worried about on the unprecedented front is if it is the case that Biden wins, I don't know how Trump will handle conceding or turning up to an inauguration and so on. But hopefully if the rest of the world is like, well, we just do this and we do a transition of power, then that's enough.
Oh boy, whole other set of questions. And who's the commander in chief the day before and the day of the inauguration? Challenging questions. Nick and Ruth, you both in different ways referred to the avenues that people who believe in everyone voting have tried to pursue to make sure that we don't have gerrymandered districts and to come up with some way that every vote is counted. what are the prospects going forward now that the Supreme Court has said that there's non-judiciability with regard to gerrymandering, and now that many of the initiatives that were on state ballots did not succeed?
Want to start, Ruth?
Yeah, well, I live in the same house as Nick because we're married, and I haven't heard this Article 1, Section 5 argument before. I'm into it. That sounds great. I mean, overall, I think in terms of the prospect of gerrymandering, the slightly nice thing is that there almost can't be as much as there was in 2010. You know, partly because the reforms, though they have been few, they have been in places that were extremely gerrymandered. So Michigan has an independent commission. Ohio adopted a system whereby you have to, even if you pass a map with one party support, you have to abide by partisan fairness. North Carolina has a state Supreme Court that's notionally controlled by the different party to the people who are drawing the maps. So I think that there will be a little bit less gerrymandering anyway. Places that can gerrymander, I imagine will, they always have. And then it will be interesting to see what the Supreme Court will, I mean, the thing I'm sort of interested in with this Supreme Court is they have always, even the quote unquote conservatives, you know, supported claims of racial gerrymandering. And to the extent that people of color are used as pawns in some kind of partisan game, I would be interested to see. I think there's a chance that the Supreme Court would strike something like that down. So that is nice. Even without, you know, being able to get partisan gerrymandering out the window, we may be able to get some other things protected.
And Virginia did adopt something.
Yes, they adopted an independent commission, exactly. And so, yeah, so Michigan's commission will stand, Virginia will have a new commission, and Colorado adopted a commission, and Ohio adopted reform. Those two were in 2018. So the ones that got reversed were Utah and Missouri. But not so bad, right? There are a bunch of places. I mean, New York adopted reform last cycle. There are places with change. So that is a good thing. You know, is it as much as we wanted? No. But Nick, want to talk more about Article 1, Section 5?
I haven't fully done research into this. I've read a little bit about it. I think it's a promising route. I think it's such a nuclear option with such potential disruptive consequences down the road that I doubt the House will pursue it. You know, just imagine the next time the Republicans control the House and they decide they're not going to, you know, seat dozens of Democrats because they claim that rampant voter fraud occurred in the election of those Democrats. That would seem to be the same kind of non-justiciable choice that a Democratic House would make in not seating members elected from gerrymandered districts. I'll just add about like what the future is likely to look like in this respect. Ruth is right. I think that we'll see fewer states with aggressive gerrymanders compared to the last cycle. But in those states that are still able structurally to enact gerrymanders, we might see the most aggressive and most durable gerrymanders in American history, because now everything is fair game and there's no possibility of federal judicial pushback. So redrawing the lines every 2 years throughout the decade to just shore up incumbents before every election, totally fine. Drawing non-contiguous districts, 55% Republicans over here, 45% Democrats over there, totally fine. Using computer algorithms to optimize the severity and the durability of gerrymandering, also totally fine. So we might see new heights of gerrymandering in the places like Texas, Illinois, Massachusetts, Maryland, Georgia, that are free to enact gerrymanders over the next few years.
The very fact that we're talking about this kind of hardened partisanship is, of course, part of the larger picture, which is whatever happens in this election, in the Senate, with the presidency, we are deeply, deeply divided. We are divided not just regionally and not just by states within states, between cities and rural communities. We are so divided. There is no blue wave. There is no clear resolution. We have different facts. We live in different media universes. We listen to different music. And I read one survey that said that 90% of Republicans were convinced that Biden would lead the country to socialism, and 80% of Democrats convinced that Trump would lead us to tyranny. So how do we move forward? as a nation, particularly with the risk that large millions of people will not see these election returns as legitimate.
So I think it's really important to recognize how really the business model of both politics and the business model of media reinforces this pathology inside of our democracy. I mean, the business model of media profits from the process of polarizing us. It's about giving us what we want. That's what digital platforms do so well, giving us exactly what we want. And what we know we want is to be reinforced in our own views. We want to be convinced that we're right. And so the media feeds us that. And as it does, we move into these wildly different tribal worlds. And the same thing at cable news. We've seen a radical polarization in cable content, cable news content, for the same economic reason. So the point is, there you're fighting the business model of media, which is a hard thing to fight. But I think the same story can be told in politics. I think that's what this election told us. Like, we thought the way to win was to rally our side and get us all really riled up to go out and vote. And the same thing on the other side. And it turned out that didn't change anybody's mind. I mean, the most astonishing intervention, I think, here was the Lincoln Project, which spent a huge amount of money to convince Republicans. It's not clear there was one Republican convinced by the Lincoln Project. And so
some independents may have been convinced.
Maybe, but the point is, like, the whole idea that they would be able to speak across and bring people over turned out to be really not based on much fact at all. And I think in both of those contexts, we've got a really fundamental problem to confront. How do we change our basic mode of interacting, both in the media context and also in the political context? Like, shouldn't our job as citizens be to reach out across and try to engage somebody we know we disagree with, rather than like sitting among ourselves and like reinforcing our own views about why the other side's a bunch of idiots? I mean, I think that citizenship has got to include the obligation to commit to building common ground, like a common understanding of the world and common recognition. That doesn't mean giving up your values or your views, but it is to recognize that we've got to find a way to build something other than just these tribal universes.
Does anyone else have a thought on this? I mean, it does seem that the divisions may require not just politics, but people reaching out to each other in a face-to-face way, not mediated by the media. But who'd like to comment on this?
I just wanted to nominate Ken to comment, because we've obviously had periods in our history where we have been very divided and we're still here. So is there anything we can learn?
Well, the way the historians typically used to answer this was that political parties were coalitions, and what you did is you shifted a little bit. You shifted an identifiable set of voters out of one party and into another, and that's how you won elections. Prospects for that seem, I would say somewhat limited at present. I was actually going to say, policy works too. I mean, sometimes it's policy that's deeply problematic, but let's say the Voting Rights Act. I mean, there was actually bipartisan consensus around the Voting Rights Act until the Supreme Court invalidated it. It was reauthorized by overwhelming majorities in Congress, and the Voting Rights Act was a deal. They elected Black representatives, and they made and the Voting Rights Act. I mean, there's a big debate about this, and but arguably the Voting Rights Act also made it easier to elect Republicans in the South. So it was a policy that both sides of a particular divide got something out of, and to some extent, that's a way to move forward when you can't agree about things. So I agree with Nick. We did all these things about court packing. We had forums on court packing. All these dreams the Democrats had seemed to be out of bounds. But there might need to be policies that are going to try to give some advantage to both sides.
I will note that David Perdue, 15 minutes ago, it was reported his majority fell below 50%. So there's going to be a runoff for both Georgia Senate races. So it's conceivable that if both are won by the Democrats, then we're closer.
I want it to be that whoever wins in Georgia should say that they will support the John Lewis Voting Rights Act, given that he is a native son.
Well, that would be quite a legacy. You know, here we are at Harvard Law School, where we pride ourselves on our diversity, including our political diversity. What might we do at Harvard Law School to build leaders in the future who can talk and work together with people from different points of view? Maybe that's a place we can end. I do invite everyone who participated here today to see, can you start a conversation with someone with whom you disagree? Maybe not in your family, because that's hard, but maybe in the school. I think that would be awesome. But I myself have learned a great deal here. And maybe there's a lesson that money in politics doesn't make a difference. You look at how much money was spent on the Senate races. Didn't seem to have moved really much of anything.
Okay, now you're just taunting me,
Yes.
Martha, because it's not, because where money matters is in how Congress votes, and that's not been proven not to be relevant.
Well, that, of course, is a huge issue for another day. And I want to give my deep thanks to each of you for your really indispensable insights. We might have to do this again soon as the world changes. Thank you all very much.
Thank you.
Love to do it. Thanks.
Thanks a lot, everybody.